we don't want to be on a list just because we're gun owners, which makes perfect sense to me, although certainly we are all on multiple lists, and Lord knows how many Richard and I have made it on at this point. We are the Armed Attorneys. Today we're talking about a recent decision from the Ninth Circuit Court of Appeals about whether or not we can all have our name and biographical information as gun owners placed onto government lists. Stick around. We're going to talk about whether or not Bruin covers gun registries. We're going to talk about whether or not the Ninth Circuit just severely limited many citizens' right to privacy. And finally, we're going to talk about whether there are any lists that are safe for gun owners to be on. But before we get started, show your support for the Second Amendment by hitting the like button.
And I think people have a natural instinct to not want to be on lists. List
Sure.
making is bad behavior generally. Governments abuse that all the time. And
Well,
conveniently,
I mean, but what if you're on Santa's good list,
oh,
though?
that's probably the one
Let's not
exception to
overly
list.
generalize.
For every rule, there's an exception. But California has been a bad actor. A lot of their lists get leaked to media regularly. Their handgun registries, their license holder registries. You don't have to go very far to find the news stories that show, hey, look, maybe this stuff isn't being safeguarded by the government very well. But we have these issues coming out of California, and it implicates, as always, New York State Rifle and Pistol Association v. Bruin. And we look at the court and how they are looking at registries with regard to the standard by which we judge Second Amendment infringements. Is the Second Amendment implicated? If so, presumptively unlawful. Then burden shifts to government to prove, based on the text of the Second Amendment, as informed by history and tradition, that this is some type of, we use the modern term regulation, and that has its own meaning. They have a different meaning when they use it back in 1791. But is this something that the government can legitimately, if you're just listening, making air quotes, regulate? But it raised an interesting issue because California collects all kinds of information on folks who purchase firearms, get licenses, and is the Second Amendment implicated? And that's kind of what the court's talking about here.
That's right. So what we have here is Jane Doe versus Bonta. So that's the Attorney General of California. So we have a challenge to Assembly Bill 173, which went into effect in September of 2021 in the state of California. And what this Assembly Bill did was say, we are going to take the biographical data, including your name, your address, your phone number, your age, your even aliases and descriptors of what you look like, right? All of your bios. We are going to send those whenever you buy a gun, whenever you buy ammunition, or whenever you get a license to carry a concealed weapon in California. We are going to send all of that information to the California Department of Justice, who is going to share it with parties who will study gun violence, right? So you are on a list, and we will share it with the appropriate parties. Now, right now, they are only sharing with the University of California at Davis and with Stanford University, but potentially there are many more parties who could come forward and say, we want to study gun violence, give us all these people's names, data, etc., so we can, I guess,
Well,
find the
let's call it what it
violence.
is. It's taxpayer-funded lobbying because they use this information to turn around and lobby for infringements on the Second Amendment. I mean, that's what they're using it for.
That's what they're using it for. So we have a challenge to Assembly Bill 173 from some anonymous plaintiffs who do not want to be named here, because the idea is we don't want to be on a list just because we're gun owners, which makes perfect sense to me, although certainly we are all on multiple lists, and Lord knows how many Richard and I have made it on at this point. But you have two challenges here. You have challenge to essentially, hey, this is a violation of the 14th Amendment. We'll talk through that in a minute. But also, this is a violation to the Second Amendment. And so really, we have this analysis by the Ninth Circuit that wonders and contemplates whether or not New York State Pistol and Rifle versus Bruin covers a gun registry. And ultimately, they conclude that no, it does not, because being on a registry, so says the Ninth Circuit, in no way affects your right to keep and bear arms. Richard, I guess we can all still wear and carry arms if our names are on a list for now.
Yeah, because we have to look at, if the list was, hey, we're going to make a list of people who are prohibited, maybe it makes it much more clear. But this is something else. And so they kind of sidestep the entire issue. And we see this is the court's strategy. If you're looking at these challenges going on across the United States, what is one of these kind of, slimy strategies courts are
Mhm.
using in order to not use the New York State Rifle and Pistol Association v. Bruin standard? It's say the Second Amendment's not implicated.
Exactly. It's the same thing as in the Texas suppressor case, arguing suppressors aren't arms, therefore do not invoke Bruin, right? Get yourself out of using Bruin is the anti-gun playbook right now. And they have done it successfully here. Now, I think there was an interesting argument made by the plaintiffs that, in fact, it does affect the Second Amendment, because once you know that you're going to be on all these lists, you're not going to want to exercise your Second Amendment right.
Yeah, there's a chilling effect.
Call that a chilling effect, right? People take chilling effects very seriously when it's something like the First Amendment.
Oh, yeah.
In fact, there are laws out there that protect your right to say things without retaliation so as to not chill the First Amendment.
Yeah, and the court has its hands tied when they're applying their own standards in the Ninth Circuit and from the United States Supreme Court about, what harm is going to befall the plaintiffs. And this is where they say, okay, this is a hypothetical harm.
Hypothetical. And so we have, that's the Second Amendment challenge, but we've got a different challenge that also ends up failing here, but again, I do not think should have failed.
Yeah.
Which is a privacy challenge. And I think what we have here is the Ninth Circuit basically tearing down part of our right to privacy. Now, Richard, do we have in the Constitution a stated right to privacy?
No, that's an implied right to privacy.
That's the problem here, right?
But California, you got some weirdos, and there's a lot of things that are private, and we have an enumerated constitutional right, the right to keep and bear arms. I don't see how we can prop up all the weirdos and then not have something for the constitutionalists.
Well, that's fair. But so what we have here under the 14th Amendment, and the reason there is a 14th Amendment challenge here is because that's what we sort of consider in the judicially created, law to be our right to privacy. So the Constitution does not ever read you have a right to privacy. Those words don't appear. But in the 14th Amendment, when we have our guarantee of the pursuit of, life and liberty, under liberty, that's where the courts have inferred this right to privacy as part of your right of liberty in the United States. And so, because it is judicially created, not written in the Constitution, the justices giveth, the justices taketh away, right?
Yeah, and that's one of the troubles that we have. And, I would say that it is a judicially recognized in that, we have the Ninth Amendment, and it instructs the federal government, hey, look, just because we wrote these rights down, people have all kinds of rights. The government, you have express powers. If you weren't given those this is all hypothetical, right? Because the federal government's out of control. But you have these express powers. If they weren't granted to you, you don't have the area to act in that. These, we look at the Bill of Rights. It's not an exclusive list. And the Ninth Amendment reserves to the people, all the other rights that aren't enumerated get selectively incorporated through the 14th Amendment. So typically, the federal Constitution only applies to the federal government. 14th Amendment makes those constitutional protections extend to the states. The states don't get to run around our constitutional rights. And so it's a frustrating prospect.
It is. And so essentially we have the Ninth Circuit here saying, well, the 14th Amendment, although it does protect your right to privacy, this isn't private information. This isn't highly sensitive information. You have, in the entire Ninth Circuit, you have no right to privacy as to your data, as to whether or not you are a gun owner or a permit holder. Just know that. And, there are some people who, I suppose, do I value my right to privacy as a gun owner? No, because I'm up here on the internet talking about it all the time. But that is my personal decision. And I think should anyone choose not to share that information about themselves publicly, that is their personal decision. And the court here makes a distinction versus like health information versus gun owner information. And to me, I don't see that much of a distinction between the two.
No, I don't either.
Because, if we're talking...
That's a good analogy. I hadn't even thought of that.
Yeah. If we're talking about, like, I don't want people to know something private about me that they might pass judgment on, they might, discriminate against me. Because,
or target me.
Well, that's the thing. In California, there are going to be a lot of people who are going to potentially discriminate against you for being a gun owner. Or, yes, do you want to be targeted for theft? Do you want to be targeted for some sort of nefarious government purpose, right? I mean, there are all sorts of reasons as to why this could, in fact, be highly private, highly sensitive information, and yet we are just given nothing by the Ninth Circuit. And I think, what's sort of upsetting about this case in particular is that its future to me seems a little bit unclear, because this was disposed of at the lower court, at the trial court level, on what's called a 12b6 motion. So it is pretty much the earliest time in federal court you can get a case thrown out, which generally means that the case has very little merit. So they threw it out on 12b6, which is failure to state a claim. The Ninth Circuit has affirmed said failure. I don't see cases like that going up to the Supreme Court.
No, that's exceedingly rare.
Under these facts, I don't see this case going up to the Supreme Court. I'm not sure where it goes from here, except that I think that California's privacy rights are just, if you're a gun owner, I'm not sure you're going to see any movement on this. And I think that brings up a question in my mind, which is, we are all on lists as gun owners, right? You buy guns from a gun store, maybe you have a license to carry. Richard, what lists are safe for gun owners in your mind now that they're all on the table in California?
No lists.
No lists. No list.
I'm a no list guy.
Oh, how do you get a license to carry if there's no list?
Well, I don't think.
The Second
Have
Amendment's
you
my
heard of
carry
it? Have you
permit.
heard of the Second Amendment?
Second Amendment. Fair enough.
But
That's what I said to my daughter. She ran away with her dad's carry permit in the house last week. I said, Second Amendment's daddy's carry permit now.
that's right.
Yeah.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And question and comment for us below. What do you think of this decision by the Ninth Circuit? Are you worried by a list like this or not? And until next time, we're the Armed Attorneys.